Hearing the appeal of oral application of Cobalt Data Centre and another against the conditions of Majesty, Revenue and Customs.
Yes, Mr. President.
My Lady, my Lords, I appear for the appellants in this matter with Mr. Venkatasan, my learned friends Mr. UKSC, Mr. Cosman, Mr. Waldegrave, and Ms. Roxandu appear for the commissioners, the respondent. Subject to the court, I was proposing to address the issues in the following order. I was going to deal first with the clause 12 point, secondly with the common law point, which is to say if the attempt at the variation was not within clause 12, was there a variation at common law? And then finally to deal with the point relating to section 298 of the capital allowances.
Yes, we've noted that you say the revenue can't take the final point. We won't decide that during the hearing.
Indeed.
So we'll hear argument on it,
Indeed.
but we have well on board your submissions.
Thank you very much.
As to why they're not allowed to.
I understand. Thank you. Before I get to the clause 12 point, which is the first issue I was going to address, can I just make this preliminary observation? There are, as this court is well aware, cases which come before this court in which the court is having to consider some ingenious scheme which the taxpayer has put together to extract from the commissioners money which it was never, or an allowance or anything else, a benefit, which it was never the intention of the legislature that taxpayer should obtain. This case is not that sort of case. In this case, the taxpayer did exactly, or at least thought it was doing, exactly what Parliament wanted the taxpayer to do, namely, to undertake potentially uneconomic industrial activity in deprived areas so that those deprived areas would be regenerated. Indeed, my lady, my lords, when the Cobalt business park in Newcastle, which is where the industrial activity in this case was undertaken, was designated as an enterprise zone on the 19th of February 1996, it was undeveloped land. In about 15 years, and consequent on the identification of this as an enterprise zone, and indeed the development which followed because of the tax allowances which were promised as an incentive, that has become the largest business park in the country, with about 2 million square feet of developed space, a working population of 14,000 individuals, served by about 1,000 buses a day. And it is, or has been occupied by the likes of Santander, Accenture, Hewlett-Packard, IBM, Procter & Gamble, and Siemens. And all of this because of the industrial development, the substantial industrial development that has taken place on the site since its designation as an enterprise zone. And I really just identify that in order to position this case as not one of those in which the revenue is, in a sense, being asked to give or pay an allowance or provide a benefit in circumstances where someone has done nothing but produced a scheme.
One picks up a certain sense of disapprobation from the Revenue's case about the leveraging of the tax benefit.
Indeed.
But I don't understand that to have any consequence in terms of the merits of this appeal.
No. With respect, that is what ordinarily happens here. You put in a third of the amount as your own money, you leverage 2/3, and that is why you get what looks like a greater benefit than you're entitled to. But there is nothing fancy or wrong about doing what they did. There may be a disapprobation, as my Lord says, but nothing to do with the merits. So that is the only preliminary point I wanted to make. Can I, having made that preliminary point, then just deal with issue 1, which is clause 12?
Just before you do, for my part, I found actually simply reading this contract rather a difficult exercise because it seems to be contained in so many different documents in so many different places. Occasionally you get some help because a relevant bit as amended is set out in someone's case. It's quite hard to find it in the bundle.
Well, perhaps I can guide your Lordship through that.
Well, it would at some stage it would
okay.
just help.
Perhaps I can just tell your Lordship.
To give one example, one goes straight from the articles to the schedule, which only contains the amendments to the conditions rather than to the conditions as amended.
Your Lordship is right about that. It does do that. It's not entirely easy to follow. So what one effectively has to do is to look at the standard form, which Your Lordship has at tab 10.
Yes.
That, as Your Lordship says, has been amended by what you have at tab 11, which is the golden contract. And then you have the schedules, and in particular Appendix 14, which is the important schedule for present purposes. It isn't easy to navigate, and I hope in the course of my
Any
submission,
shortcuts to scholarship that you can provide will be appreciated.
we will do that, and perhaps at the end,
What would be useful would be have a consolidated version
of the key
of the key provisions. They are, as my Lord says, dotted about in the
Indeed.
submissions. But
and there are not that many key
No.
provisions, so we ought to be able to do that, and we will provide that. I'm grateful. So Clause 12 is obviously a matter of contractual interpretation. I'm going to come to Clause 12 in a moment. Before I do, can I just show the court first Change Order 2? Because in a sense, this all turns on whether Change Order 2 was within Clause 12, and also whether, if it wasn't within Clause 12, whether it involved a variation. So if I can just take your ladyship and your lordship to that quickly, you'll find it at Core Volume 2, behind tab...
We don't work that way, Mr. Reverse.
You want a page number?
I'm afraid we very boringly use an electronic bundle with page numbers.
Page 650. For those who are using bundles... 650.
Thank you. I appreciate you'll have to use both systems because your colleagues...
So Core Volume
are using
2, for those who are using paper, tab 16, 650. And what you see first, if you go there, is the covering letter which accompanied Change Order 2. You see it's sent on the 1st of April 2011 in accordance with Clause 23A, and just for the court's note, you'll find that at page 423. I'm not asking you to turn that up. That's the notice to proceed provision. In accordance with Clause 23A of the contract between the Highbridge North Tyneside Developer Limited and yourselves, dated the 17th of February 2006, that's the golden contract. We're authorised by the employer to instruct you to proceed with the works in accordance with Change Order number 2, dated 1st of April 2011. And if you go over the page, you see...
Page 650 is the notice to proceed.
Page 650 is the notice to proceed, and then page 651 is the change order. Just to identify a few aspects of it, you'll see it's Works Option 1. So it's a change order to Works Option 1, identified as change order number 2. And then under Clause 12 of the contract between the developer and the contractor, that's the golden contract, we have been authorised by the employer to issue the following instructions. So certainly it was purportedly under Clause 12, as you see, and then this: undertake the design, construction, commission of one number data center 2, DC2, totaling 3,360 square meters net technical space, together with support facilities and enclosed plants. The work will include, etc., and then the price is stated. So that's, in a sense, what the fuss is all about. If I can next take you to Clause 12.
there it says, from the date of a notice to proceed under the contract. But is it right, then, that the covering letter is, in fact, the notice to proceed?
It does appear to be a notice to proceed because Clause 23A is the notice to proceed provision, and it does say this is in accordance with Clause 23A. If I can invite the court next to go to Clause 12.1, which you have at page 352.
352.
352. And before I take you through the detail of this provision, can I just make 4 introductory points, and the introductory points to variation clauses in construction contracts generally. The first point is this. As the court will understand, I'm just trying to position this, as the court will understand, unilateral variation clauses are very common indeed in construction contracts. Indeed, they were so described by Mr. Justice Aikenhead, obviously a specialist in the field, in the Superblast case, that's at paragraph 29, and for the court's note, that is at volume 2C, tab 65, page 2636. The reason why unilateral variation clauses are so common is because of what one textbook writer describes as the inherent features of the construction process. This is, I'm not inviting you to turn it up, you have an extract to Sargent, it's paragraph 1.26, that's page 3102. He describes this as the inherent features, one of the inherent features of the construction process. For example, construction processes can last for a very long time, and as indeed my learned friends accept at paragraph 15 of their case, changes often need to be made to the contract to deal with unforeseen circumstances. And if the employer did not have a unilateral power of variation, every such change would require the contractor's consent. And as the editors of Hudson on building contracts note, that type of situation would expose the employer to unacceptable pricing pressures, which is something that is avoided by including in modern construction contracts, as they almost invariably do, unilateral variation clauses. For the court's note, that's Hudson, paragraph 5-019, page 3091. That's the first of our 4 points. The second one is this. Not only are unilateral variation clauses very common in construction contracts, but consistently with the reasons why they are so common, they are also usually very wide in scope. And obviously this doesn't tell you whether this particular one is wide in scope, but they are usually wide in scope. And again, the court may wish to note that this is again a point which is accepted by my learned friends at paragraph 69 of their case. That's at page 86. And it is also a point which is reflected in the standard texts on the subject. And again, the reference is, I'm not inviting you to turn it up, to Sargent, paragraph 5.4, page 3104. The third introductory point is this. The very fact that they are common and that they are included in widely used standard form contracts, such as the JCT standard form, which is what we're dealing with here, suggests, we would submit, that they are, despite being widely drawn, in general not perceived by the contractors to be unfair. And there is a very important reason why that is the case. The industry does not see this as problematic, that the employer should be given a wide unilateral power of variation, because in these contracts there is a quid pro quo which is included in return for that wide unilateral power of variation. And as the court will be aware, the quid pro quo is that the exercise of the power usually triggers other contractual provisions which protect the contractor. For example, provisions that give the contractor an automatic extension of time, provisions that give the contractor a right to be paid for any extra work at market rates, and as one finds in this case, and indeed as is part of the standard terms, a provision which effectively provides the contractor with a blocking right if what is being sought is unreasonable, in which case he can simply not consent to it. And as I will endeavour to demonstrate in due course, that is also the position under the Golden Contract. The fourth introductory point is this. The 3 points that I've made so far, we would respectfully submit, indicate why, as we submit, it would not be surprising if Clause 12 of the Golden Contract, which is of course based on the standard form, gave the employer a wide right of unilateral variation. There is an additional reason we respectfully submit, specific to the Golden Contract, that reinforces that general point. And that arises from a factual finding made by the upper tribunal, which the commissioners do not challenge, at paragraphs 33 and 107 of the upper tribunal judgment. I'm not inviting the court to go there. That's pages 167 and 183. That finding was that the Golden Contract was entered into for the purpose of preserving the ability of the parties to claim enterprise zone allowances on construction activity in the future. That was the common objective or a common objective of the parties to the golden contract. And as we say at paragraph 14 of our written case, page 18, the parties made the golden contract in circumstances where they knew or would have known that their ability to claim EZAs, or the preservation of their abilities to claim enterprise zone allowances, would only continue to exist if there was sufficient flexibility in the golden contract to enable the parties to undertake such construction activity as might be foreseeable in changed circumstances in the future. Now, obviously, having made those points, have to satisfy the court that clause 12.1.1.1, and indeed clause 12.2, is wide enough to accommodate the variation which the parties sought to make in by way of change order 2. And I'll come to that now. But the reason I make that point, or the points I've made, my lady, my lords, is really in order to, in a sense, make this point that there is, we would respectfully submit, no good commercial purpose that would be served by imposing limitations on the employer's power of unilateral variation. Because all the points I've made, really, in a sense, are designed to identify the commercial context in which this takes place. So to the language of clause 12, if I may.
Just pausing there. What we're looking at on page 352 is this just the JCT standard form?
Yes, it is.
Right.
And it has been varied in a way, a minor variation, but one that my learned friends say matters. But this is the JCT standard form. You can see that if you go to page 341.
The upper tribunal, at paragraph 73 of its judgment, sets out clause 12.1 as amended, I think. It's at page 175 of the e-document bundle. And page 72, I think, sets out 12.2.1.
Can I then take you through it, and the court will obviously look at whatever version of this it finds most helpful. I was going to take you through 12.1.1 first, so just picking that up, page 352, or from the upper tribunal judgment. The term change in the employer's requirement, or change, means 12.1.1, a change in the employer's requirement which makes necessary the alteration or modification of the design, quality or quantity of the works, otherwise than such as may be reasonably necessary for the purpose of rectification pursuant to clause 8.4, including, and then 12.1.1, the addition, omission or substitution of any work. And then just 12.2, still on page 352 if that's where you're reading it. The 12.2.1, the employer may, subject to the proviso hereto and to clause 12.2.2, you may want to put brackets around and to the contractor's right of reasonable objection set out in clause 4.1.1, because that has been removed by amendment, and hopefully that is reflected in the upper tribunal judgment. So the employer may, subject to the proviso hereto and to clause 12.2.2, issue instructions affecting a change in the employer's requirements. No change effected by the employer shall vitiate this contract, provided that the employer may not effect a change which is or which makes necessary an alteration or modification in the design of the works without the consent of the contractor, which consent shall not be unreasonably delayed or withheld. Just pausing there, my lady, my lords, as the court sees, clause 12.1 is a definition provision. It defines the term a change in the employer's requirements. But the power actually to make the change comes not from that provision, but from clause 12.2.1, which, as the court has seen, says that the employer may, subject to the proviso, effect a change in the employer's requirements. And we would just note, as the court may already have picked up, as indeed as I've just mentioned, the words in 12.2.1 and to the contractor's right of reasonable objection set out in clause 4.1.1 should be notionally struck out, because those words, which are in the JCT standard form, were removed by an amendment made to the Golden Contract. And again, for your note, Golden Contract, clause 12.2.1, at page 405, you'll see that.
But, sorry, I'm getting a little, I mean, the and to the contractor's right of reasonable objection set out in clause 4.1.1, that's deleted.
That's deleted.
So we shouldn't
forget about that.
Indeed.
We still have the proviso at the end, but those words have been deleted.
Yes.
Maybe I should just show that to you, so to put it clearly. If you go to page 405, very
Provided
quickly.
that, yes. I mean, if it's been deleted, it's wholly irrelevant, isn't it?
Well,
I mean, you've got the proviso. That's what
you've got the proviso.
Yes. Yeah.
If it wasn't for the proviso, it would be very relevant. I'm not saying it's irrelevant, but it's less relevant because you've got the proviso.
There.
So if you see at page 405, towards the top of the page, is a reference to clause 12.2.1. It says in lines 1 and 2, delete enter the contractor's right of reasonable objection set out in clause 4.1.1. So that's removed, the proviso isn't removed. That's clause 12, and there are, as we respectfully submit...
Sorry, can I just... what was the logic behind that deletion, given that the proviso at the end remains?
It maybe someone thought it was redundant. I can't answer the question, my lord. The only conclusion I've come to is they thought there was a proviso anyway. Why do we need this as well? So that's clause 12.1.1. And as the court knows, we respectfully submit that there are two reasons why the work, why change order 2, which I showed you, comes within clause 12.2 really, and it is this. The first relates to the language of clause 12.1.1.1. The term change in the employer's requirement or change means, and then you have the introductory language, and then it says including the addition, omission or substitution of any work. And in our respectful submission, what cannot be doubted is that what change order 2 did was to add work. So on the face of it, and I need to deal with Malone and Friends' points in response to that, it's difficult to see why change order 2 doesn't come within the language of clause 12.1.1.1. And if we're right about that, subject to my learned friend's point about section 298, that is the end of the case. We have a second point that we make.
So your point is that this point, which I think is described as a linguistic point, is that any of the things that fall within 12.1.1.1 or 0.2 or 0.3, that list of 3 things, if any of those happens, because of the word including, those are necessarily within the meaning of the term change in the employer's requirements.
Precisely that, my lady. Precisely that. And I'll come on to make a submission about the word including, but this court certainly doesn't need to be told that if you have, whether it's a statute or a contract or anything else, the word including, and you then have a list of things which are to be included, then they are included. And in a sense, it doesn't really matter what the words before it say, because whatever they say, if it requires that they be expanded and read differently in order to include what you're expressly told need to be included, so be it. But what you're told will be included is included. And what is included here, as we're expressly told, is a variation which adds any work.
You say there are no limits to that
No,
at all?
I don't say that. We will look in due course at Lindsay Parkinson and two other cases which have been cited here. I'm not going to take you to because they say something similar: Blue Circle and Thorn. What those cases make clear. Let me say first what they don't say. What they don't say is that as a matter of general law, the general law imposes a limit on variation clauses to prevent them being too wide. There is no such rule of general law. And to the extent that either the Court of Appeal, Lord Justice Lewison, or my learned friends advance such a proposition, in our respect for submission, that is plainly wrong. What those cases do say, and what we respectfully submit, is that you can't just look at one provision in a contract and say, well, it says that, and I'm going to ignore everything else, which tells me everything else about what was in the contemplation of the parties, so that there is, in this case, no limit. You have to construe the contract as a whole in order to identify what is generally within the contemplation of the parties to this contract in terms of the sort of variation that would come within this provision. Now, what is going to be important in our respectful submission when one embarks upon that, as we'll see from Lindsay Parkinson, is to identify the limits of the protection which are given to the contractor. What mattered in Lindsay Parkinson, as we'll see, is that the limits in terms of financial reward which the contractor was given in that case was capped. And the issue in that case was, could you include by the way of variation any amount of work, however much it was going to cost, in circumstances where you capped how much the contractor was going to get for it. And as a matter of contractual interpretation, the court said you could not do that. And it implied a term to prevent that. So we entirely accept that in the end, you will look at other provisions of the contract. My learned friends say the contractor's not as protected as it might have been. And as I understand it, they say that in order to, in a sense, put something into the argument here about whether you need to read an implied limitation in here, we don't accept that there is not sufficient protection. But we accept as a general proposition that you cannot, under this heading, ask them to do any work. You can't ask them to build, I don't know, a power station in Timbuktu. You can't even ask them to build a power station in Surrey or Sussex, which is, I think, the example that Lord Justice Lewison took. Because that is plainly not within the contemplation of the parties to a contract which involved the development of an industrial site in an enterprise zone near Newcastle.
But it goes, I mean, as a matter of language, doesn't the addition, omission, or substitution of any lowercase work have to be within the envelope of the uppercase works?
With respect, no. Because you're being told by the word including that whatever the uppercase work, well, there are 2 points. The first is, given what it says and given that it's introduced by including, does it matter what
I'm not really focusing on including.
No, I understand that. But including matters, because including would say, forget about what the envelope is. You're told this is going to be included, regardless of the envelope.
Well, no, but that you're presupposing what 1-1 means.
I said there were 2 points, and I'm going to come to my Lord's point, which I think is the second point. The second point, which I think is being suggested, and indeed was very influential both with the Upper Tribunal and the Court of Appeal, was to say that although it says any work, there is a limit on the work that you can do, and it is provided by the definition of capital W work. So you can do any work you like as long as it comes within the ambit of capital W work. And again, we respectfully submit that that is wrong. And if I can come on to...
When you say capital W work, do you mean works, capital W works?
Capital W works.
Right, yeah. I just wanted to check there wasn't another term.
I mean, your point would be stronger if it was the addition, omission, or substitution of any capital W works.
Yes. With respect, Maybe it would be stronger, but in my respectful submission, it's strong enough anyway. Can I just develop the point about why the word work doesn't provide, if you like, a limit? May I come to it by just deal first with the inclusive point, just to sort of get that out the way, and then I'll come to this, if I may. I've already made the point about the language of inclusive. There is also authority, insofar as it is necessary, which supports what I say about the word inclusive. And the cases which we refer to in that context are the case of Dilworth in the Privy Council, which was followed by Reynolds in the House of Lords, and I'll take you to it in a moment. But effectively, they illustrate this point. Let's say you have a statute, let's call it the Animal Protection Act. And the Animal Protection Act says that protection is to be given to animals, and then it says animals includes cows, sheep, and computers.
Cows, sheep,
and computers. Now, for the purpose of that statute, computers are animals.
This is the old Cambridge thing. Cats include dogs.
Cats include dogs.
Yes.
And that may be an extreme example, and it may be you'd have to eliminate the possibility of an error. But as a general proposition, that is right, because you've been told by statute that whatever you would ordinarily think, and indeed whatever something else may say about what animals are, for the purpose of this particular provision, animals includes computers. Dilworth, if I can very briefly show that to the court, and I appreciate that in a sense one doesn't need authority to support this to the right as a matter of contractual interpretation.
Mr. Rabinowitz, just before we leave page 352, do we have in the bundle the clause 4.1.1, which has been deleted?
4.1.1.
If we did want to follow what was being done, we have it somewhere.
If you go to
Page 350.
it'll be in the JC.
page
350.
350, thank you.
Oh, right, okay.
So Dilworth, if I can invite you to go to that, the court will find at page 1685, for those using paper, volume 2A,
Sorry,
tab
give me the
33,
page reference again. I'm awfully sorry. What?
page 1685. So this was a case which was concerned with the construction of Section 2 of the Charitable Gifts Duties Exemption Act 1883. And you'll see Section 2 quoted in the judgment of Lord Watson, page 1690, at the bottom of the page. The detail doesn't matter, you'll just see that it says charitable purposes includes. If I can then invite the court to go to 1691, about 7/8 of the way down, the last paragraph on the page, you see this. Section 8 is beyond all question an interpretation clause and must have been intended by the legislature to be taken into account in construing the expression charitable device or bequest as it occurs in Section 3. It is not said in terms that charitable bequest shall mean one or other of the things which are enumerated, but that it shall include them. The word include is very generally used in interpretation clauses in order to enlarge the meaning of words or phrases occurring in the body of the statute. And when it is so used, these words or phrases must be construed as comprehending not only such things as they signify according to their natural import, but also those things which the interpretation clause declares that they shall include. But the word include is susceptible of another construction, which may be imperative if the context of the act is sufficient to show that it was not merely employed for the purpose of adding to the natural significance of the words or expressions defined. It may be equivalent to mean and include, and in that case it may afford an exhaustive explanation of the meaning, which for the purpose of the act must invariably be attached to the words or expressions. So just pausing there, the distinction that Lord Watson draws between two senses in which the word includes can be used in an interpretation clause, depending on whether the word means is also included, does not actually matter for the purposes of this case. Because what is common to both senses is that the items enumerated in the inclusive list are covered by the preceding words, even if they would not have been covered by the preceding words in the absence of the inclusive list.
Well, the word including is often used to clarify. So there might be argument as to whether something was included in the general word, so you have the including. It's not necessarily to enlarge, it may be just for the avoidance of doubt.
Well, it may be for the avoidance of doubt, but one way or the other,
Yes,
it includes.
it has that effect.
Indeed.
Yes.
It's perfectly possible that there is tessellation, to use a word my clerk likes, between what follows the word inclusion and what comes before, since there's no conflict between the two. But if there is conflict, since the conflict, what prevails is what follows the words including.
Yes.
Now, just to be clear, we don't have to worry about the sense of the word means and includes. I mean, all that was being identified there is you can have an interpretation provision which, by virtue of the way in which it uses includes, it's really intended to say includes this and no more. We don't have to worry about that. I only make that point because my learned friends in their case say that we've been selective in our quotations, and if you read on, you'll see a part of it, the means and includes, which helps them. With respect, it doesn't help them. It's really just irrelevant to this particular case. So that is the Dilworth case. I mentioned the Reynolds case. I wasn't proposing to take you to it. It's the House of Lords case, which effectively adopts and follows what is said in Dilworth. If I can just give you a reference to that, it's page 2308. The relevant part of that is at 2317.
2317? Thank you.
So we respectfully say, in light of that, if the court would look again at 12.1.1.1, what it means is what it says, which is the addition of any work is to be regarded as part of the employer's requirements, subject to the point I've made about...
I don't know, can you just help me on this? The exclusion of the protection in 12.2.21 of the contractual right of reasonable objection might be said to require a more cautious look at the ambit of what is included than if that right to object was there. Because if I'm thinking in terms of some rational protection to the contractor from an exposure to being asked to do anything, including build something on the moon, a right of objection would be probably a perfectly good protection, however wide the enabling words were. But if it's not there, one has to have a much more cautious look, doesn't one, at the enabling words?
Your Lordship would be entirely right in a contract which didn't have protection. But as my Lord Richard pointed out, we've removed, well, what has been removed is clause 4.1.1, but you've left the proviso. In other words, you still have the protection. You still have a blocking right for unreasonable requests. And undoubtedly, with respect, I don't think it goes to how you would construe clause 12.1.1 and inclusion, and the word including, or indeed the addition of any work. What it would go to is the Lindsay-Parkinson type analysis, which says, even though this is very wide language, we have to impose some limitation by implied term or otherwise in order to account for the fact that otherwise this contractor would be completely unprotected, as they were above a particular limit of expenditure in Lindsay-Parkinson. And so in Lindsay-Parkinson, I think it was the Court of Appeal, imposed a limitation by way of an implied term. Now,
it's strange that it's only 4.1.1 that's... So 4.1.2 still applies, that if the contractor can't object because 4.1.1 is removed, and then if they don't comply within 7 days, the employer can bring on somebody else to do the work and make them pay for it. Is that what that means?
That may be, again, it may be ill-fitting in this case, and one could quite see how it might suggest that the contractor is in a sense repudiating the contract because they're not doing the work, and it does allow a very short period of time. I agree with that. So that's the language of clause 12.1.1. Now, coming to my Lord Richard's point, it is said, and by the commissioners, and indeed by the Court of Appeal, that clause 12.1.1 doesn't enable a change to the employer's requirement that would necessitate a change in the definition of the works themselves. That's effectively the way it works. That the natural limit of what you can change by way of the addition of works is provided by the capital W works. You can change anything within the capital W works, but nothing beyond that. And for the court's note, one finds this at paragraph 77 of the upper tribunal judgment, that's at page 176, and also at paragraph 66 of the Court of Appeal judgment at page 131. Now, the first point we would respectfully make about that is that it is immediately apparent that clause 12 obviously does not say that explicitly. Nobody has pointed to any words that say that the power to vary, including under 12.1.1.1, may not be exercised if to do so would necessitate a change in the definition of works or work options. And that being so, we would respectfully submit that it is fair to describe the limitation which the courts below imposed, and for which my learned friends submit. It would be fair to describe that limitation as an implied limitation.
But that's a bootstraps argument, because it presupposes that the proposed change is within the clause, and you need something expressly to say it's outside.
Well, in my respectful submission, you do, because of the language of inclusion, because it says including the addition of any work.
But that goes round in circles, because we come back to what is meant by lowercase work.
Well, I mean, work is,
and also
as opposed to uppercase works.
Well, indeed, it's very. I mean, I will show you what uppercase works mean. And lowercase work means something different because it's lowercase rather than uppercase. So uppercase work is clearly defined, and I'll show you exactly what it means. But any work lowercase means exactly what it says, any work. There is no natural limit.
Does lowercase work then become uppercase work if an instruction is given?
Precisely so. And the question, that is, indeed. So if you have, that is the argument. We have definitions of works, which I'm going to show you. The issue that arises on clause 12 is this. Is there, by implication, I would respectfully still submit, a limitation on the ability to seek to vary by the inclusion of any work? Is there a limitation which is imposed by the definition of uppercase work? And I'll show you what that means. Because if there is, as I say, number one, it's certainly not expressly said. Number two, it would, with respect, produce completely absurd consequences.
Sorry, the point I just wanted to raise with you before we leave this, I mean, 12.1.1 says change in employer's requirements which makes necessary the alteration or modification of the works.
Yeah.
So, I mean, could it be said that there are some inherent limitation in the fact that you've got to alter or modify the works, not completely depart from them?
Well, I mean, if you're completely abandoning the works, so that, for example, we were in, I don't know, power stations in Surrey, then I'm not going to dispute that that's not within this provision. But an alteration of the work by the addition of any works modification of any works, in my respectful submission, is not a natural limit, and it's particularly...
Sorry, where do you say you get your power station limit from?
So the power station limit comes from an interpretation of what the parties could possibly have contemplated by a contract, which was to build, and again I'll show this to you, one or other of a variety of different types of building in an enterprise zone near Newcastle.
Right, but which words would you fasten on to get that limit then?
Well, we know, in fact, I would say you don't actually find those in particular words. You just stand back and say, here was a contract which was to build something in an enterprise zone near Newcastle, and the number of different types of buildings that are identified as possible buildings that you may have to build is pretty wide, and it may include more than one building. But they're all going to be built in an industrial area near Newcastle. So and the reality is, if you're looking for words, then there wouldn't be a natural limit here, because you would simply say any work could be any work.
Yes, thank you.
But just
so
further to your point.
Your case is that if it's an addition, omission, or substitution of any lowercase work, then it must also be the alteration or modification of the design, quality, or quantity of the uppercase works.
Indeed. That's part of my case. I mean,
there are plenty of examples where it wouldn't involve that, aren't there? I mean, you could have the works, we know what they are,
of course.
but you could require some changes to them, which would be an addition, omission, or substitution of any lowercase work.
You could build an extra window.
Exactly.
In fact, as I'm going to show you, there are 222 pages of employer requirements.
Yes.
And the argument that is advanced is you can change any one of those 222 pages worth, but not a single one which may affect the definition of the works. Just to be clear about what the definition of the works are, I'm going to take you through this. But for example, works, well, let me take you through it slowly in the way that I was going to, just so that you see the point.
But I mean, we have established, therefore, that you can give very full meaning to this clause within the envelope of the capital W works.
You certainly can, and you can limit it in the way that my learned friend is my lord is suggesting you can do. It produces absurd consequences.
Okay.
And you're doing it by implied. You're reading words in because you have to, because it says including, and you are producing, with respect to completely absurd consequences, which I'll come on to. So let me just develop the point in this way. Can I just show you the definition of works and how this actually works, lowercase for the second works there. You'll find the term works defined at page 386. 386. So works, if you're there, means the design, construction and commissioning the employer wishes to obtain for the works option stated in the notice to proceed, which for the avoidance of doubt shall either be works option 1, works option 2, works option 3, 4, 5 or 6, and referred to in the employer's requirements and the contractor's proposal for that work option, and including any work needed to ensure that the tests on completion and the performance tests are passed and any changes made to these works in accordance with the contract. Works option 1, which is the one that we are concerned with, means, so works option, let's just look at works option first, means works option 1 or works option 2 or works option 3 or 4 or 5 or 6, as the case may be. And then if we go to work option 1, lower down that page, it means the design, construction and commissioning work comprising an industrial unit to accommodate the manufacture of an 8-inch board on Site C, for which works the employer has issued to the contractor its requirements, hereinafter referred to as Works Option 1, Employer's Requirements. Now, what these work options therefore do, as you see, is to identify the intended use which is to be made of a particular unit, to identify where it's going to be, and what you will then find is the employer's requirements specifying the detail which you obviously have to build in order to give effect to a building which has that description in that place.
So works option 1 just comprises that paragraph. Everything else describing what you actually have to build is in the employer requirements.
Precisely. And we know that you can amend and vary the employer's requirements. Now, if the point about the definition of works providing a limit on what the works could do, on what the amendments, the variations could do, was correct, it would mean, for example, that although you could amend every single one of the employer's requirements which go towards producing this, you couldn't amend a single one, despite the express power to do that, you couldn't amend a single one which in any way changes this definition.
Could you change it so it said comprising an office block on Site A? Would that fall within Clause 12?
The way, with respect, you have to ask the question is, if there are provisions in the employer's requirement which are provisions which go towards the construction of an office block, are you, despite the express power to vary anything in the employer's requirements, are you not allowed to vary any of those which are material to the construction of an office block?
But, I mean, the works requirements are bound to be directed to an industrial unit. I mean, it's inconceivable that, because everyone knows that an office block is very different from a factory. So it's bound to require very extensive changes to the employer's requirements.
My Lord is quite right. And Clause 12.1.1 says you can add, substitute, or vary, change any of the employer's requirements.
So the answer to my question is yes, that you could substitute office block for industrial unit.
You could, because the way in which you're specifying how you get to an office block will be set out in the employer's requirement, which you're told you can change.
Yes.
And the argument against me...
The employer's requirement has to be related to a particular works option, isn't it?
It has to relate
employer's
to...
requirements for that works option, 1, 2, 3, 4, 5, or 6.
It has to relate to it, but,
Yeah.
but the question is...
How does it relate to that works option if you've changed it to be something completely different?
You have a new works option. The question really is
Is there
this.
a power to add or change the works options?
That arises as a necessary and inevitable consequence from your power to change anything in the employer's requirements. So if you have...
So the answer to my question is no, there's nothing actually in the contract that says
There is no...
you can change works option 1 to mean something completely different from an industrial unit to accommodate the manufacturer.
With respect, I would have said the answer to your question was yes, because if you can change the employer's requirement in every single respect, which you're entitled to do,
Well, that's the question.
that's the question. But there is no language which limits the employer's requirements that you can change.
But why doesn't the definition of works option not set the sort of the broad target?
Well,
So that it's inherent implied that the employer's requirements have to be aimed to that broad target. You seem to be sort of putting it the other way round.
I am putting it the other way around.
Yeah, no,
because
I
putting it
appreciate
this way around, with respect, produces absurd consequences. Let me show you why. And then I'll show you the employer's requirements as well. If it were right that this provides a limit, you see in the definition that it's in order to produce an industrial unit to accommodate the manufacture of an 8-inch board on Site C. So what if I want to change the employer's requirement to produce a 7-inch board? Am I not allowed to do that? Or a 9-inch board?
What I'm not clear about is whether the manufacture of an 8-inch board rather than a 9-inch board requires any change to the design and construction of the relevant industrial unit.
But let's assume it does.
Right.
Let's assume it does. Well, here's something which we don't have to assume. What if instead of having it on site C, I say I want it 10 yards further on? So it overlaps but is not completely on site C. Am I not allowed to do that?
Well, why do they bother putting in how many inches the board is if it's not an important point?
Or to put it another way, why set out a series of options if the ability to change is so great that effectively the nature of each option is just irrelevant because you can change
Well, it's not irrelevant because unless you do change it, that is what is going to be built. It's absolutely relevant and important because subject to
well,
your
I'm sorry,
variance-
I mean relevant in terms of constraining what changes to the project can be ordered unilaterally by the developer.
With respect, why does one consider this as relevant to constraining? It's plainly relevant because this is what's going to be built, subject to a variation. So it's certainly relevant and important because unless I vary, this is what's going to be built. The next point is, what my Lord puts to me is why include this if it's not relevant to the changes that you can make? In my respectful submission, why should it be relevant? Why should it be regarded as a natural limit on the changes that you should make, where you have a provision which is intended to be wide in scope, where the contractor is completely protected if you change your mind, and frankly doesn't care if you use this for industrial boards of 8 inches or 9 inches, doesn't care if it's on site
How do
C
we
or
know
10
they
yards.
don't care?
Because they're being protected, they're being paid.
You say that, but I mean,
They are
they
big
may. I mean, there's an air of unreality, if I may say so, about this, because what had happened with this contract is that the option had already been exercised. The contract, in that sense, was at an end. What you're seeking to do by the exercise of a unilateral power is to impose a whole new building obligation on the contractor.
With respect, the point about the option having been exercised arises not in the context of clause 12. It
Well,
obviously
why not?
arises.
Why not? I mean, your argument is that you can exercise the power under clause 12 in circumstances where the contract up to that time has been fully performed.
Well, it hasn't been fully performed.
Well, why not? Because I
Because
thought
it
that the
hasn't.
option had been exercised and the relevant building had been constructed or was in the process
Perhaps
of
we can just
construction.
test that proposition.
Right.
My Lord,
I mean,
puts
am I
to me-
right as a matter of fact?
You're right as a matter of fact that an option had been exercised. It was an option to build works options 1 and 3.
Yes.
My Lord is putting to me that if those options are exercised, in a sense it's the exhaustion point which you see in the Court of Appeal, if those options are exercised, then you can't possibly have any right to vary.
No, we're not on the variation point. We're on clause 12.
Indeed, under clause 12.
So what you're saying is that the employer has a unilateral power, subject to the protections you've mentioned, to impose on the contractor an obligation to build a completely new building in these extraordinary circumstances, as I would suggest they
With
are.
respect, can we take that in stages? Because the building hadn't been completed.
Was it being constructed?
It was certainly being constructed, but your Lordship
Well,
says...
so
but your
you say
Lordship
to the contractor, OK, you're building the factory there. We're now going to require you to build a second factory over there.
You move from one point to another. Your first point is, I've exercised a right, that's it. The next point your Lordship is putting to me is a different point, which is, you've completed the building, that's it.
Well, no,
You need to
never
deal with
mind whether
both.
you've completed it.
But it matters.
The contractor is under an obligation by virtue of the notice to proceed in respect of options 1 and 3 to construct a building. As I understand it, you say that clause 12 gives to the employer the power to impose an obligation to construct another building which is not contemplated within the existing option.
Let's just test that. Plainly, the fact that I've exercised a work...
I mean, is the statement correct or not?
With respect, in my respectful submission, it doesn't stop you doing that.
No, all right, but sorry, then the statement is right, and you say, and you'll go on to say why it's within clause 12. The statement is right.
The statement that your Lordship is putting to me
is that clause 12 confers on the employer a right to require the contractor to build a second building when under the contract as it existed until that moment, the contractor's obligation was only to build one building.
With respect, the answer is that completely ignores the blocking right, number one. The blocking right. There are two questions. Now, the first is...
It doesn't necessarily ignore it, but you have to say you're within clause 12 before you get to the blocking right.
In my respectful submission, you would be in clause 12,
Right.
but because of the blocking right, when your lordship puts to me the proposition that it enables the employer to impose on the contractor the obligation to build a second building, with respect, that is wrong, because you have a blocking right. And of course, the more absurd the example you want to put to me, the more the blocking right will come into effect.
Well, like you say, it's an absurd example, but it's actually this very case.
No, I'm not. With respect, what happened in this very case is that the building had started. It hadn't been completed.
Well, you say the building, the first building. We're now concerned with the second building, aren't we?
We're concerned with a second building.
It wasn't a exercise of clause 12 to change the specification in respect of the building already under construction.
No, it wasn't.
No.
But if I can just try and answer the points, because it'll come up later. There are two possible ways in which what your lordship is putting to me matters. The first is the suggestion that once you exercise a right to choose a particular option, clause 12 can't have any role. And that's obviously not right. I'm not saying that this is what you're putting to me as being correct, but that's plainly wrong. I could choose, let's say, an option to build a unit for semiconductor plants, and I could say you're 2/3 of the way finished, indeed you're 5/8 of the way finished, or 6/8 of the way finished, which may be similar, but I'd like you to put a few more windows on, or I'd like you to add garages. No possible problem with that. Second way in which this becomes relevant is in circumstances where I've not only exercised that right, but it's actually being built. And in a way, my first example captured that. Even if it has been 90% built, there cannot be any reason why I can't even then exercise my clause 12 rights and say, actually, before you finish, I'd like to vary the size of the driveway. I'd like to vary, I don't know, the number of doors that you're going to put in. No problem with that at all. So there is no limit in terms of how far you've got with the building in which you can do that. Now, your lordship puts to me a situation in which I've asked for the construction of one building, and now I want to vary that to ask for a second building.
Well, hold on. No, you've not only asked for the construction of one building, that is being or has been performed.
Absolutely.
So it's not that I've asked you to build one building, now I'm asking you to change that building.
Fine.
It's not just asking, it's actually the work being done by the contractor, either being done or completed.
So let's take an example. One of the works options here is for a business park, which involves a series of units. 90% of the way through, I say, can you build 90% of the way through a further 3 units for that building, business park? Any reason why that can't be within clause 12? With respect, I can't see why. You have 90% concluded one building or 2 buildings or 3 buildings, however many it may involve.
That's all within the one option, isn't it? Works option.
That's fine. So here you have one building, which is a data center, which is change order 1, which changes it to a data center. And then someone says, I would like to have a second data center. So I'm obviously adding to the work.
Well, hold on. You're creating a new work option, aren't you?
I'm certainly adding to the lowercase work. And by definition, your lordship is right.
Well,
the effect of that,
I'm not...
the knock-on effect of that is to vary what works option 1 was, whereas previously, in fact, it never was, anything to
it's a change. Sorry to interrupt you again, but it's a change in the employer's requirements. The employer's requirements are fixed to a particular works option, aren't they?
With respect, they identify what has to be built in order to give effect to this. But I am expressly told that I have a power to change the employer's requirements. And the question that arises is, why should my power to change the employer's requirements be limited?
So you're saying that if they had already got an 8-inch board on site C in accordance with the employer's requirements, then the employer using clause 12 could have said, I now want to add a second industrial unit to manufacture a 9-inch board on Site C, and that is part of a new employer requirement for Works Option 1, and subject to the protections, you must do that, and by changing the employer requirements for Workshop Option 1 in that way, I have also changed what Works Option 1 means from the meaning set out at page 387 to a new meaning, which is work comprising 2 industrial units, one to accommodate the manufacture of 8-inch board, one to accommodate the manufacture of a 9-inch board. So that's the logic of what you
That is the logic. The logic is, if you look at clause 12.2, it says the employer may, subject to the proviso, issue instructions affecting a change in the employer's requirements. And then it's got a proviso. And the question...
Can I just ask 2 points? So it seems to me that in an answer to my earlier question, you have an ultimate controlling limit of it's got to be within what you described as the contemplation of the parties.
Mm-hmm.
So that's why you couldn't change Works Option 1 to include a nuclear power station in Liverpool, on your analysis. Yeah. Can I just ask about the block that you've told us? When you say the block, do you mean 12.2.1, the proviso? Is that what you mean, by the block? And that means, does it, that the contractor can always decline anything, provided that the declining is not unreasonable?
Well, you say anything. This says, provide the employer may not effect a change which is or makes necessary in any alteration or modification in the design of the works without the consent of the contractor, which consent shall not be unreasonably withheld. So it's not anything. It has to change. It has to be something which makes necessary a change in alteration or modification of the design of the works. So certainly the nuclear power plant would be different. Even what we're describing now, a second building would plainly be a change in the design of the works, and that could be blocked. So you're putting to me circumstances in which I do keep talking about the protections, and I make no apology for it because the protections here are important. You're putting to me as if this was entirely non-consensual and in a sense the imposition of something unreasonable. In fact, because the contractor has the ability to say no but doesn't say no, it's consensual where you are dealing with substantial variations. Do
you accept that when somebody, whoever it is, has to decide whether it's reasonable or not, the contractor would say, well, I only signed up to make 1 building. I haven't got time to make 2 buildings. I've got other projects I want to do. I didn't think I was signing up to a contract that just said you must build whatever we tell you to build at any point, as long as it's vaguely in the enterprise zone. I mean, the fact that they've taken such care to specify the options and the employer's requirements must, I think, be relevant to the reasonableness of the contractor's refusal to implement it.
With respect, that's a point in my favour.
Yes.
Because it's perfectly possible that he could have said, that's unreasonable, it's not a works option, you're changing the works option, and I could block this if I wanted to because it's unreasonable, but I choose not to.
Is there anything in the point that the blocking right at the end of 12.2.1 is only in relation to things that change design, whereas the right to alter enables you to alter or modify design quality or quantity? I mean, suppose the original requirement was to build 1 factory to a very specific, if you like, out-of-the-box design, and then he comes along and says, oh, actually, I want 3. No change in design, same factories, just turning the handle 3 times instead of once. Is there a blocking right in relation to that under 12.2.1?
There would be, because the design of the works, rather than simply being one building, would be for 3 buildings.
So why do they include quantity or quality in 12.1.1 and not in 12.1.2?
Because, well, quality is easy. Quantity may be number of windows, number of...
But that would, on your case, affect design. I design a building to have 1 window per room, and you suddenly say, actually, we need
Your Lordship may be right.
2 windows per room.
Your Lordship may be right. But in my respectful submission, the wider the blocking right that exists in the proviso, the easier it is with respect to give the words the natural meaning in 12.1.1.
And there may be nothing in it. It just
No, I understand what Your Lordship is saying.
It's a definite textual difference.
There is a textual difference.
Sometimes textual differences don't
There is a textual
matter,
difference.
and sometimes they do.
There is a textual difference, but one can quite see that if you're going to be saying, I don't want a building, I don't want a unit which is going to design these semiconductor things, I want a data plant, a data center, someone says, well, you can't do that. So it doesn't actually, I think what I'm saying is that one doesn't have to read in limitations to clause 12.1.1.1 in order to protect the contractor from being made to do something which is unreasonable, because he's protected from that.
But do those words design, quality or quantity, do those reflect sections of each of the employer's requirements?
I don't understand that they do. I don't understand that they do. I ought also, just to show you, let me start from a different place. The issue which I've been debating with my lady and my lords goes to whether or not I can, by changes in the employer's requirements, bring about what is in effect a change in the definition of the works options. And my case is, if I can bring about changes in the employer's requirements, this doesn't identify any natural limit. You are therefore going to have to say you're implying this limit, number one, and you wouldn't want to do it if it were absurd. Now, I've already tried to give you an illustration of why we respectfully say it would be absurd, because if it were right that the definition of works option 1 defined the natural limits of any change in the employer's requirement that I could give, then because the definition includes a reference to 8-inch plates, it would follow that I can't change anything in the employer's requirement which relates to 8-inch plates. I can't move it off site C even by a yard. And the question is, why would anyone have intended to prevent the employer from introducing that sort of variation? And in my respectful submission, there is no good reason. In circumstances, again, I'm picking up a point that my Lady Rose put to me. First, if the contractor doesn't want to do it and it is unreasonable, he can say, I don't want to do it, it's unreasonable. Secondly, if he does want to do it, whether we think it's unreasonable or not, A, he'll get paid a market rate for it. B, there is a provision in the contract which extends the completion date to accommodate this. And so the question is, why would you be reading natural limits into this and not giving effect to what the parties expressly agreed? What is motivating?
Would that change not be a change in the design of the works? Again, just picking up the language of 12.1.1 and 12.2.
It would. It would, which means that in a sense this is a consensual variation, because the contractor who could object is choosing not to object.
Right. But you seem to be seeking to construct a sort of argument from HMRC, which puts you into a straitjacket, and you say, well, no one could have realistically think we were in a straitjacket. And therefore, you seem to go the whole way and say, and we could have a new building because we changed the employer's requirements.
No.
But what I'm wondering is whether there might not be a sort of halfway house between those two, that if you're dealing with modifications in the design of the works. That allows for some adjustment, but still within the brackets of the works as already defined, apparently by the dominant provision in the definition of Works Order 1.
So with respect, let's leave aside the proviso for the moment. Okay, I'm not saying it's irrelevant. It's plainly irrelevant.
Yeah.
If the starting point.
Sorry, just on that, I thought you were positively saying it's relevant because the existence of the proviso means, well, people might have expected changes to come through, but if one limits the proviso, one might think, well, that has some implications for how widely the changes.
Your Lordship is right. Your Lordship is right. I do very much depend on the protections for my interpretation. If the protections weren't there, then, as in Peabody, one can quite understand the court trying to find limitations. But the protections are there, so that's very important. The point that I'm making about the revenue case, and indeed the way in which it was approached by the Court of Appeal, and indeed the Upper Tribunal, and indeed what underlies a lot of the questions which are being put to me, is that surely you cannot construe, before you get to the protection, the blocking right, you cannot construe the language in 12.1.1, which says I can add any work, as entitling me to add any work which changes the description of the works options. And so when I say, and I give you with respect, absurd examples which show that's being absurd, I haven't yet got into the blocking right. I'm just saying it cannot be right that these parties could possibly have intended that the definition of the works options provides a limit as to the extent to which you can change works.
Why not?
Yeah.
Because it produces absurd results.
But, I mean, it doesn't seem to me natural, really, to say that there's a change in the design of the works, capital W works, which are defined as a factory, to say we now want an office block. I mean, that's not a change in the design of the factory. It's the substitution of a completely different type of building.
With respect, my Lord is putting to me an example, apparently, I suspect in order to say that's an unbelievable change. Why? From the point of view...
I'm trying to limit what does design, a change in the design of the capital W works mean? That's what I'm trying to, that's
Indeed,
why I'm using the example.
You're saying, can it possibly have been intended that you could do...
You could substitute one, quote, works for another, quote,
and the question is this. From the point of view of the contractor who's building the building, he couldn't care less what you're going to use it for.
Well, he may care very much that he's in the business of doing one type of building, but not another type of building.
And then he could say it's unreasonable, and I'm stopping you from doing this.
I see. So, but the real point is the extent of the opening words before you get to the proviso. I understand your point about the proviso.
The real point is the extent of the opening words,
yes,
having regard also to what is within the contemplation of the parties. So let's rule out, because this couldn't have been in the contemplation of the parties, building a nuclear site in Surrey or Sussex.
Right, that's moving the location. What about a nuclear power station on the Cobalt business park?
He would plainly... again, is that within the contemplation of the parties? Well, that's a more difficult...
It's not really, is it? Because you've got to be a very specialist contractor to build a nuclear power station. So it's a rather extreme example.
Well, it may be an extreme example. It may be an extreme example. And again, you could say, well, that would be outside the contemplation of the parties.
Yes.
But what we're talking about here, let's just be clear. The evidence, the finding of the Upper Tribunal, on the basis of the evidence before it, was that what was being built here was not terribly different to building a data center is not terribly different to building a unit for the production of these conductor boards. It involved not including certain equipment, but other than that, it was basically the same. So if you're talking about the contemplation of the parties and you're talking about a building which was basically the same and was 20 meters somewhere else, we're not talking about nuclear plants or office construction buildings, or anything which would be outside the contemplation of the parties. We're very much talking about something which was plainly within the contemplation of the parties. What we're talking about is a variation in what the building was going to be used for, because the evidence before the Upper Tribunal was basically the building was the same. And the question before this court was, why is that not within clause 12.1.1? The building is basically the same. It's 20 metres different in terms of the site, and it's plainly involved the addition of works.
It seems to me that it might be said that the builder still has an interest before you get to the consent not unreasonably withheld point. So if you take the arguments about whether he's a specialist in building factories rather than office blocks, if he's able to say, well, that's just gone beyond what I can be required to provide, he's spared the argument, which might be quite a tricky argument, as to whether he is unreasonably withholding his consent.
Yeah. I mean, I'm in the fortunate
Can I just add to
position.
that before you answer? And spared having the answer to that argument provided by somebody else than himself, in this case probably an arbitrator or a mediator. And
indeed, but the question is, where does that, in a sense, ability to say you can't ask for this come from? In my respectful submission, there are some types of work which you could say is outside the contemplation of the parties. Yeah. The question, however, but we're not dealing with that sort of case. Let's be very clear about it.
I mean, what
because
they contemplate is what they set out as the works options. I don't see
because the building.
You can say there's some kind of penumbra around the works options, which is within their contemplation, even though it's not a nuclear.
Well, if one is saying we're simply driven by the language here, and it is not possible for the court to say, for example, I don't know. Leave aside the language, you cannot be expected to come within, and you can fit this into your language argument by saying you can't build a nuclear site in Surrey because that's not within clause 12.1.1.1, because that's not a works option point. You can say that, and I can see that. But again,
may I also say, I have a bit of difficulty with your saying, well, it's not in the contemplation of the parties as a test. I mean, usually with contractual interpretation, you find the words, and the contemplation of the parties informs the meaning you give to the words, rather than having some free-floating, well, you're within the words, but it's not in the contemplation of the parties.
Well, you'd have an implied term in circumstances where...
All right. Well, can I put to you again my question? You accept, there are limits, the nuclear power station limit. Where spell it out for us. Where do you get that limit from the contract, either by
it's a change in design. It's certainly a change in design, and therefore within the blocking right. But I think your question is, why does that not come within 12.1.1?
Yeah.
Where does that come from? Because if you have a contract between parties to build a series of different types of building, because that's what this was, there were 6 different works options, they involved different types of buildings. If what you're doing is building a different option in a different location, in my respectful submission, any court would say, whatever the language here, that is not within it's not whatever the language is, because this is to build something within an enterprise zone near Newcastle at Cobalt Park, that it is not within the contemplation of the parties that you could build, that you could be required to build a nuclear power station in France.
But in a highly sophisticated contract of this kind, which contains a blocking right, which imposes an arbitrarily decided standard of reasonableness, you would think that the parties would want to have some things set in stone and other things left to a reasonableness standard to be determined by an arbitrator. And if you then look into this contract and see, well, what is set in stone and what is subject to reasonableness, aren't you left with looking at what each of these options does? And for this purpose, you've probably got to look at all the options to understand how Clause 12 works. And in each case, the option defines the purpose of the building and the location of the building, and leaves everything else to contractors, to requirements. And isn't one driven to the conclusion that the bits that can't be changed are the location and purpose, and pretty well everything else can be changed? Now, you may say, well, why is it so important that it should be an 8-inch rather than an 9-inch bore? But we're not builders of factories that design sophisticated computer components. We don't know. That's what the parties have chosen to put into the option.
But your lordship knows this much. The variation power, as I say, there are 222 pages of employer's requirements. We don't have the full selection here. You are told you can change any of the employer's requirements. So, for example, you could change it from being 1 story to 2 stories or 3 stories.
Yeah.
What my lord is putting to me is that although I could change from 1 story to 2 stories to 3, make it twice the size, half the size, a quarter of the size, what I can't do is change the use of the building so it's producing 9-inch plates instead of 8-inch plates. And in my respect,
just because that's what the parties have written into the
with
contract.
respect, but that's you're in a sense that's a bootstrap argument. You're assuming that that's what they've said, and I'm saying it isn't what they've said. That is what this court has to decide. Have they really said that? Because in my respectful submission, it's absurd to think that that's what they've actually intended. I know that they've said these are the works options, but there's also a variation power which enables you to vary, as I say, 222 pages of employers' requirements. But your lordship is putting to me that although I can double the size of the building, expand the cost by hundreds of millions, the one thing I can't do is move it 2 yards to the left or change it so that instead of manufacturing 8-inch plants, it manufactures 7-inch boards. In my respectful submission, that is not an outcome which could possibly reflect the intention of the parties. Now, I accept that is what you have to decide. And on the one hand, there is an argument, my argument, which says there is no language which tells you that. Against me is put, you have to imply this. And I am saying you don't imply things which produce absurd results. You don't imply things which can't possibly make a difference to the contractor. But that is the argument that I'm facing. There is no provision here which says there is a natural limit which is imposed by the works option.
Well, we may have to beg to differ on that.
Well, that's the, you
because
have to decide.
I think as some of the points put to you is that there is an express limit, and it's contained within Clause 12, that what you can't do is to go from one, quote, works to another works. Now, I understand your submissions, but can I just go back to the contemplation of the parties, which I think you acknowledge to be a limiting factor on the operation of Clause 12. What this contract contemplated was that the employer could give a notice to proceed to the contractor for the construction of one of the works options, or, as a result of the variations, either 1 and 3 or 2 and 3. But that was what the parties contemplated. Right. That is what happened. So what change number 2 and number 3 did was to extend the scope of the contract in a way which was quite outside the contemplation of the parties when the contract was made.
With respect, that is, I with respect don't accept that, because what the contract provided for was the ability to make a variation in the employer's requirements. And if the variation in employer's requirements...
Can I just... But this wasn't a variation in employer's requirements. It was an addition of a wholly uncontemplated additional obligation, which...
With respect, you say wholly uncontemplated. What Clause 12.1.1 actually says?
Because the contract as a whole contemplates the execution of one of the options.
Or more than one of the options.
Well, but one piece of work, either one of the options or 1 and 3 or 2 and 3, but nothing else.
With respect, that is fair. And then that is what the contract says.
Yes.
And then it also has an express power to add to the work.
Well, that's the point, though. I mean, given what the contract provided, which gives us, as my lord says, really identifies what the contemplation of the parties is, I find it difficult to understand how you say that Clause 12 expands the contemplation of the parties to include one additional, or maybe a number. I mean, would there be any limit to the number of additional buildings that could be required under this contract? Could Clause 12 be exercised? It was exercised twice here. Could it have been exercised another 3 or 4 or 5 times?
In my respectful submission, what would limit that is the blocking right, but not Clause 12.
Would be the
blocking right in Clause 12.
Yeah, I see. So it's just that.
So,
right.
I think I probably used up the amount of time I'm going to use up on issue 1.
I was going to say
I'm going to move on
to
issue 2 if I can. So just give me 1 second, if you would. So issue 2 only arises if the court is against me on issue 1, and it concludes that there is, in fact, no power within Clause 12 to vary in the way that there has been a variation here. And the question that arises on issue 2 is whether, if this wasn't a contractual variation, was it in any event a variation at common law? As you know, the upper tribunal concluded that it was. The Court of Appeal concluded that it wasn't. The approach of the upper tribunal was to say the question of whether there's a variation or not depends on intention. And it also said, and perhaps I'll show this to you, that what matters particularly, or what mattered here, particularly in the context of intention, was the tax point, the tax context. That this was, in fact, a contract where the background to the contract and what to the variation, what the parties were very concerned to achieve was to ensure that they stayed within the golden contract, because if they didn't, they would lose the ability to claim tax allowances. Can I just show you what the upper tribunal said at page 180?
Um, 180.
180.
There's a separate key
I
document.
think you're in a different bundle.
The key documents.
Key documents.
Can we not operate out of the main bundle?
No, it's not in there. I don't think it's in
The
there.
key document bundle.
Well, the judgment's in there.
Is it?
No one.
I wasn't sure it was.
Yes,
Okay.
it is. It's
I'll go to the. Don't worry. I'll go to the key document.
228, apparently. Thank
Oh,
you.
is it? Okay, sorry.
Bundle.
It is there, but
it's
never mind.
in an
It
annex
is.
to the
Okay.
statement of facts and issues.
Yep.
So, paragraph 96, Mr. Cosman submitted that their lordships had laid down a principle to the effect that where the differences or inconsistencies between the later agreement and the existing agreements were so fundamental as to go to the root of the contract, then this was sufficient to constitute an implied rescission. We do not accept this submission. It seems to us that this case is authority for the proposition that the difference between rescission and variation is dependent on the intention of the parties. In the absence of other evidence, the fact that changes affected by the subsequent agreement go to the root of the existing contract, or that some changes are inconsistent with the contract's original terms, might lead to an inference that the parties intended to rescind the contract, but the question remains one of intention. So that is the test that the upper tribunal adopted. And then, in terms of its conclusion, if you go, please, to paragraph 106, which is at page 182 of the key documents bundle. 251, thank you.
I'm in the key document now.
Are you in the key?
I've given up. Everybody else is in the key document, so I've surrendered for the first time.
I'm sorry.
Ever.
182.
Paragraph.
182. Paragraph 106. Applying a test based on the parties' intention, we are in no doubt that they intended the change orders only to vary the golden contract, not to rescind it. This case is far from the type of case referred to by Lord Justice Toulson in Samuel and Wadlow, where the parties do not turn their minds to the somewhat legalistic question of whether or not a variation is intended to rescind the original agreement. Viewed objectively, the parties to the golden contract clearly intended that contract to preserve the entitlement for someone to claim EZAs on construction expenditure on the site. The change orders were similarly intended to result in a building being constructed that was somewhat different from those provided for in the golden contract, but the EZAs nevertheless still to be available on the cost of construction. Mr. Williamson, QC, was correct to submit that the parties' common desire to ensure that EZAs would be available to the purchaser of the building ultimately constructed is strong evidence of a common intention that the change orders would not result in rescission. So that was the approach of the upper tribunal. The Court of Appeal, or at least Lord Justice Lewison, appears to have adopted a different approach. And I should say at the outset, it is not completely clear what approach Lord Justice Lewison did adopt. And I'll explain what I mean in a moment. What appears to have been the approach that he adopted, this is reflected in his textbook, is what he described as a two-stage approach. The first stage was said to be what the parties have agreed, which Lord Justice Lewison agreed, depended on their intention objectively ascertained. The second stage was said to be what is the legal effect or legal consequence on what the parties have agreed. And according to Lord Justice Lewison, at the second stage, the intention of the parties is irrelevant. And as Lord Justice Lewison put it, or at least identified as being the Commissioner's case with which he appeared to agree, this is at paragraph 72, as he said, it is not competent to the parties to agree that a particular change should take effect as a variation rather than as a new contract. And for the Court's note, the identification and application of the two-stage test is at paragraph 72 and paragraphs 106 to 114 of the judgment of Lord Justice Lewison. Lord Justice Newey took a...
So just to be, I mean, paragraph 72, Lord Justice Lewison sets out the two rival submissions.
Yeah.
And where, just, sorry, I didn't get down if you referred us to it, the paragraph where he sets out his conclusion.
Well, he sets out the rival submissions.
Yes.
And then if your Lordship looks, so a lot of this is citing authority,
Yes.
including
Yes.
paragraph 113, Street and Mountford, paragraph 114 where he says the intention is not at large. And then one gets to paragraph 117 where he says, in my judgment, the upper tribunal were wrong to have rejected the submission that they recorded at paragraph 96. If you go to paragraph 96 at page 180,
Right.
that is where Mr. Cosman had submitted that their lordships had laid down a principle to the effect that where the differences or inconsistencies between the later agreement and the existing agreement were so fundamental as to go to the root of the contract, then this was sufficient to constitute an implied rescission. We do not accept that submission. So he's rejecting, he's saying that the upper tribunal were wrong to have rejected the root of the contract approach, which is what the...
Which is not quite the same as the two-stage approach, the legal consequence being a matter where intention is irrelevant. Because Mr. Cosmin's submission, as recorded in paragraph 96, is a much more focused submission than that.
Your Lordship is right. It's not entirely clear that Lord Justice Lewison did adopt a two-stage approach, or indeed that Lady Justice Andrews, who said she was agreeing with paragraph 147 with Lord Justice Lewison, adopted a two-stage approach either, because although there are passages where it looks as if there is a two-stage approach, if you look at other parts of what Lord Justice Lewison is saying, and certainly what Lady Justice Andrews is saying, they do look at intention.
Yeah.
But your lordships and your ladyship in any event have to deal with the two-stage approach because Malone and Friends are still urging that on you.
I mean, in a sense, a test of changes so fundamental as to go to the root of the contract is a kind of intention.
It's
test.
Perhaps I can just articulate what we say the approach is. And then I can show you a lot of authority. It's going to come to...
I was simply trying to understand, I mean, you may have shown us all that you can, but just to do the best we can to see what the basis of Lord Justice Lewison's judgment is. That's what I was anxious to do.
It's not, with respect to Lord Justice Lewison, it's not that easy to follow because he does set out the submissions of the commissioners on the two-stage test. He never anywhere says that is wrong. He doesn't actually say what is right.
No.
And so all you have, and I don't mean that in a disrespectful way, what one has is long passages which set out and articulate a two-stage approach. No identification that that is wrong. But then there are passages where plainly he's looking at intention. Even, well, we say there are no two stages, there's just one stage, and it depends on intention. And there are aspects of his judgment which reflect that approach. So
he does seem to be saying that the second approach is a categorization exercise, like what's a lease, what's an employment relationship, whatever. And that does seem to be a second stage at which intention is not relevant.
That may well be what he's saying. I, with respect, I'm not convinced that that is throughout what he's saying. There are aspects of what he's saying where he doesn't split it into stages, and he does just look at intention. On the other hand, one does get to the points of intention, of exhaustion, and of the SDA, where it's not clear what those are intended to go to, and that may be part of a second stage.
Is your submission that there is just one approach and that is the objective intention of the parties?
Indeed.
That's it?
That is it.
Because, I mean, sorry, forgive me.
Pursue that. Doesn't that then produce, I mean, one can understand that there may be a strong submission, the objective common intention of the parties is of paramount importance. But however strongly one puts it, doesn't there come a point at which you can't simply be relying on the objective common intention of the parties? So, for example, I mean, just to take an absolute extreme case, if there's a contract entered into in July 2006 and it's fully executed, and then the parties, for a particular reason, decide afterwards that they're going to vary the contract by pretending that it was actually entered into 10 years later. So they vary the contract by inserting a completely different date of commencement. One wouldn't say that that is a variation, even if, according to the common intention of the parties, that's what they were intending to do. If they actually said, we are varying that contract by inserting a different date. I'm just giving you a completely absurd example to make the point.
With respect, Your Lordship, he's giving me an absurd example, which in a sense is an example about a kind of sham, where people...
Well...
but when you're dealing with a sham contract, you don't normally have regard to what the parties say they intended, because you know it's a sham. So in a sense, that doesn't falsify an approach which says it is intention that matters, and there isn't a second stage of categorization. It just identifies that there may be a natural limit to intention when you're dealing with something where what the parties have said can't possibly reflect their intention. Now,
so is your submission that it's either objective common intention or the only limit is sham?
I'm not going to say the only limit, because I'd be a fool to say that, because it's always easy to falsify anyone who says the only limit. There may be other circumstances in which, for whatever reason, and in my respectful submission, you do have to look at all the circumstances, the court says, I don't accept that this actually reflects the objective intention of the parties. Lord Sumption, in a case called Plevin, which we will go to, makes it very, very clear, and indeed Lord Justice New in this case does something similar. They make it very clear that the test is one of intention. Lord Sumption, in paragraph 13 of Plevin, then says, and he's dealing there with the express statement of intention rather than the implication of intention, says, you may not give effect. It is possible that you may not give effect to an express statement of intention, in that case to vary, if it's for some completely different subject matter. Mm. But even there, he's not saying it's not about intention. He's saying you have to look carefully to see whether this can really objectively reflect the intention of the parties.
I was setting up an absolutely absurd example just to see what your answer to it is. I think your answer is at that point you reach sham.
Yeah.
Let's come back to a less absurd, but nevertheless extreme example. We've already been talking about it. Let's assume that the parties buy a an alleged variation, contract to build a nuclear power station in France, as you gave that example. Are we saying that that is still governed by the objective common intention of the parties? They may even do it, I suppose, by a variation, express variation contract. Does that class, in your view, as a valid variation?
Yes, it does.
Right.
There's no reason not to give effect to the intention of the parties, absent a sham. Now, look, I apologise. This may arise in a context in which there is a statute. It could be an employment statute. It could be a statute of the sort that one had in the Eastern Caribbean, which is about whether the government can give away properties for peppercorn rents, where you say, for the purpose of the statute, I don't care what you said. I don't care that your intention was to vary, because your intention to vary here was in order to achieve some nefarious, non-achievable objective, and you can say what you like, it's not going to count as a variation for the purposes of that statute. But there what is happening is you are categorizing. It's a matter of the interpretation of the statute at that point.
It's an Uber point, isn't it?
Precisely, it's an Uber point.
What counts as an employment relationship is not the common law test.
Exactly.
Or a rent tax point. I mean,
or a road tax point. Or a point of the sort that arose in the CMK case, which Millen and friends like to refer to. It's not about the common law contract.
Isn't the your submissions on this a basis of just a pure abstract question of common law? But don't the cases show that what is always going on is working out which of two things something which the parties have agreed to create is, lease, license, or employment or not, or doesn't one always have to do it?
No.
In the context of the statutory provision which makes that choice relevant?
With respect, no. And I think there was an acceptance in this case that this is a pure contract law.
Well, I know, I'm just
and it's not that your lordship puts to me that it always happens within a context. Of course, the key cases here, Morris, Bennington's, probably Shukar as well, arise in circumstances where it is a pure question of the common law. There is a statute in Morris and Bennington's which comes into play, the statute of frauds, which prevents the variation being effective.
Yeah.
But that's not, with respect, a part of the court's analysis in terms of whether what you are dealing with in those cases was a variation or a rescission. It is a pure question of the common law. There is a different question which arises in this case, the Section 298 question, which is whether what you've arrived at in the end of the day is a contract which is of the sort that Section 298 contemplates. But a prior question that arises is the common law question as to whether, as a matter of pure common law, what happened here, if it wasn't under Clause 12, and one has the sense that your lordships may and your ladyship may feel that it didn't happen under Clause 12, if it didn't happen under Clause 12, was that a variation or was there a new contract? Pure common law question. And there are cases.
That's entirely governed by the objective common intention of the parties.
Your lordship keeps putting to me the entirely point, and I keep saying, in general, I would say that it is governed by intention, and there is no two-stage categorization as a matter of common law. And what the court has to do is to determine the intention of the parties. I'm not foreclosing the possibility that you will have cases of sham or cases where, for whatever other reason, the court says, I don't care what they've said, I don't care about anything else. That is not an intention to which I can give effect for whatever reason, because it's a sham or something else.
It's not, you may have varied it or replaced it. Even if you've varied it, the expenditure is not being incurred under a contract entered into within those 10 years because the supposed variation you've made is outside the 10 years.
That may be, well, with respect to variation, if it's a variation, then it was under a contract entered into within those 10 years.
Well, I slightly question that. I find it difficult to, if I may say so, to put aside these pure questions of common law from the context, which is section 298, because a variation is a contract, and that's how you achieve a variation. So, I'm then left with the puzzle, well, the variation's outside the 10-year period, the initial contract was inside. Are the works carried out under a contract, being the variation, or and therefore outside the 10-year period, or under a contract being the original contract, and therefore inside? Just addressing it as a pure question of legal theory doesn't seem to be helping me, at any rate, answer that question.
Well, of course, the reason that the appellant won before the upper tribunal was on the basis that if there was a variation, a common law variation, then the expenditure was pursuant to a contract which was entered into within the first 10 years, as varied. The reason we lost in the Court of Appeal was because the Court of Appeal said the expenditure was not incurred under the contract that you entered into in the first 10 years because there was a new contract, and the expenditure was therefore incurred under a new contract. I think what my Lord is putting to me is the possibility that neither of those things reflect the statute, which perhaps this is not, which is that you have to have incurred the expenditure under the terms of the contract, the particular provisions which incurring the expenditure being provisions which existed in the first 10 years. That is the issue 3, which we'll come to. In my respectful submission, that's not what the statute says. But before you get to that, you have to, with respect, consider issue 2, which is, was this a variation or was it a new contract? Because unless Miller and Friends are right about their statutory interpretation point, if it was incurred under a contract entered into within the first 10 years, even though varied, it was still incurred under that varied contract, subject to the point which arises on the statute.
Well, what if the contract, the original contract, provided for works of type A with a date on it, which is a qualifying date, and the parties decided they wanted to do something completely different, and they simply removed everything from the contract except its date. This contract is made between and the parties, X and Y on date, and then put in the new works by way of, and by the way, we declare that this is a variation. Is that a qualifying contract under the Act? Because everything that has been agreed to be done will have been agreed after the expiry of the 10-year period.
Again, that is an issue for issue 3.
Well,
but you say it would be a varied contract.
It would be a varied contract.
You say under issue 3 it would
count.
be done because the effect of the common law is to treat it as all in the original contract.
If it's
questioning that.
With respect, if you issue 2 is about when is a variation, when is this new contract which the parties have made, I'm going to call it a new contract, to be regarded as a variation? When is it to be regarded as not a variation and simply a new contract? When also it may arise the question as to when does it rescind the original contract, but we don't have to worry about that here. You first have to decide that issue. In other words, if what happened here was that we entered into a new contract which was not a variation at all, so that the expenditure was under a new contract, then we accept that the expenditure was not incurred under a contract entered into within the 10 years because it was incurred under a new contract which was not entered into the 10 years. That's issue 2. There may be a further point, which is whether in the circumstances of this case, even if it was a variation as a matter of common law, that can still count for the purposes of section 298, 1B. So with respect to, there are separate points, and in my respectful submission, the court really does need to consider issue 2 first, i.e. was this actually a variation or did this give rise to a new contract, before you get to issue 3.
It's just that on one view of issue 3, the variation rescission point just doesn't matter. I mean, if one took the view on construction,
of course, your lordship is right.
What the section is really about is seeing whether these works were committed to within the 10-year period. Then it wouldn't matter whether the commitment to the works by the variation that later occurred is or isn't to be regarded as a common law a variation of the original contract.
That is precisely the point which is made by my learned friends in the context of issue 3.
Yes.
Which we'll have to come to. In my respectful submission, they're wrong about that, because that's not what the statute says. But we first have to consider issue 2, because we don't even get to issue 3 unless I'm right about issue 2. Well, we will get to it because it's an important question, but...
Yes.
I mean, I think we should keep to issue 2 at this point.
Yeah.
We're going to come up with these questions, presumably in issue 3. But I'm still struggling with the idea that this is all a matter of objective common intention, subject to what you've said about sham, because let me put it to you this way. The law must at some point take a view, irrespective of the parties' common intention, as to what classes as one contract and what classes as a different new contract. I think conceptually, the law has to ultimately make that decision. Now, if you're not agreeing with that, then, and you are saying, well, it's all really a matter of objective common intention, then I would understand the submission. But it might alternatively be that you're saying, well, that's at such an extreme point that it doesn't apply in this circumstance where we've got a very clear common intention of the parties and we haven't got anything like the sort of extreme circumstances where the law might want to say, well, whatever the intention of the parties, just as a matter of law, that cannot be the same contract.
Am I agreeing with it or am I not agreeing with it? Can I put it in the way that I want to put it, which is this. There will be circumstances where the law will say, we don't care about the intention of the parties. And that will normally be because of the context in which the issue arises as a matter of the interpretation of some other area of law, be it the law of land law or some statute. You say, I don't care that you say this is a lease, because actually it doesn't work as a lease. Okay, that's one example. Another example may be the Uber case in the context of employment law, but these are all where you have an overriding context in which you have to, despite what the parties intended, categorize it. So the question of the categorization arises in that way. Your Lordship is putting to me, I think, a case where it's just as a matter of pure contract law. Does pure contract law, which tends to depend on the intention of the parties, have within it some, I don't know, red line, blue line test which says, no, we don't care what the parties intended because what? Now, I'm not saying there can't be a because what, but I'm saying that as a matter of the general approach of the common law, what you look at, it's not a two-stage approach of the sort that my learned friends are suggesting, where all you do at the second stage is compare the two contracts and say, well, it's kind of fundamental change. There's a fundamental change. It can't be a variation. In our respectful submission, that is wrong, because it may give you the right results, but that's because of the intention of the parties. I think that is a point that my Lord Richards put to me about changes in the contract reflecting intention. I don't have any difficulty with that as a proposition at all. The only issue that actually arises between the parties is whether that's the only thing you look at. Because if you have a two-stage test of the sort that Lord Justice Lewison identifies, and indeed for which my learned friends wish to advocate, you look at intention at the first stage, and even if the parties have intended a variation, you then say, aha, but we're going to compare the terms of the contract, and if there has been a fundamental change, if the change goes to the root of the contract, we don't care about your intention. That, in my respectful submission, is very confused indeed. And the reason I say it's very confused, I do not say that changes in the terms of the contract don't matter. They absolutely are relevant, but they're relevant to the question of intention, which is a question which takes into account all the circumstances, which is what the court keeps saying, House of Lords, what Lord Sumption has said, what Lord Scott has said, what Lord Devlin has said.
Subject to changes in the basic subject matter.
With respect, they don't say that. Sorry, Lord Sumption, and indeed Lord Justice Newey at paragraph 136(8), reserve the possibility, they do it slightly differently. Lord Sumption in Pleven having made it absolutely clear that this is a question of intention, reserves the possibility that where there is a change in subject matter, you may not have regard to the intention, that you may ignore what the parties have said their intention is. That's effectively what he's saying. But he doesn't say it's, you have departed from a test of intention. He's just saying there may be circumstances in which you, for whatever reason, looking at all the other circumstances of the case, you don't give full weight to what the parties have said their intention is. Lord Justice Newey frames it differently, but he's plainly trying to capture the Lord Sumption example at paragraph 136.8. And in our respectful submission again, Lord Justice Newey, we respectfully say, has correctly set out the law, provided that what he's doing at 136.8 is not intending to go any further than Lord Sumption. It is ultimately a test of intention. My Lord,
I suppose the difference is, as you say, Lord Sumption was raising the possibility the description given to the transaction by the parties would not necessarily be
not necessarily, exactly.
If. Now, admittedly, there isn't such a description as such here, but in a sense, Lord Justice Newey is actually applying that limitation.
That may be what is happening.
Yeah.
But it is, with respect, there is, in my respectful submission, not a single case, other than an Australian case, which suggests the two-stage test, as opposed to the Lord Sumption approach, which is effectively to say there may be extreme circumstances, and I'm not saying his particular circumstances is extreme, because he doesn't say it would. He says it may mean you ignore intention.
Would not necessarily be conclusive.
There may, my Lord Burrows wants to say, I'm not going to paint myself as an absolutist here. I'm not going to say I cannot contemplate any circumstance in which the court says we simply do not accept what you say is the intention, and we are going to, for whatever reason, say that cannot have been a variation. There must be cases. You put me a sham example, and I accept that's one case. If you come up with another example, I'll try and deal with it. But our basic point.
If I was to, let's just switch entirely, and we're talking about a holiday contract. So I enter into a contract on a standard form with a holiday package company, and I'm going with my family for £3,000 in July, and then it's apparently varied, so that I'm now going by myself with my wife to Paris, completely different price, a completely different time. Now, it might be that the parties have said, well, we're just varying that contract. But I'm putting to you that the law might take the view that there is a point at which they just cannot regard that as the variation of the same contract, and that the law is saying, conceptually, that is a different contract, and that it may be an extreme point at which the parties' intentions, in that sense, aren't given effect to, but nevertheless, there is a point. And I don't think that's a sham.
Well, with respect, I wouldn't accept that that's not a variation. You put to me, let's take your example and say you go to a particular travel agent on the Strand and you book a holiday for two in Paris, and then you decide you want to take the kids, and in fact you want to go to Brussels, but there is a contract which has been set up for you for a number of terms, and you expressly agree that rather than going through the whole thing again, you'd like to vary that so that instead of there being two people, there'll be four people, and you want to change the destination, and there is an express agreement that it's a variation. With respect, why should that not be a variation? What is the principle of the English common law which says that in that particular circumstance, you should not have regard to the intention of the parties? What possible policy comes into play so as to say, in a situation like that, we're going to disregard what the parties have intended, because you're putting to me something which doesn't have the penumbra of, we need to categorize this.
Exactly.
Because I can quite see that if you have something which says there may be further tax on this, for the purposes of the taxing statute, I may have to have a decision about, I don't care what the parties have said, I'm treating this as a different contract. But as a matter of pure common law, with respect, it is completely contrary to the principles of the common law to intervene and say, I'm going to ignore the intention of the parties. That's our first point here.
Thank you.
Can I put this to you? The law has to decide whether an arrangement between A and B is a contract or not. The intention of the parties is not the sole determinant of that question. So the law, for example, will require consideration.
Yep.
So however much the parties wish the promise by A to pay £100 to B to be binding, the law will say it's not binding because there's an absence of consideration. So in determining whether there is a contract in the first place, it's not dependent entirely.
I accept that.
Of course, the intention of the parties is very important, but it's not entirely dependent.
I accept that.
So why, as a matter of principle, shouldn't the law also apply its own view to whether there is a new contract?
Because there is a policy for consideration, for whether you need consideration of that. There's a policy of law which says you shouldn't have a contract unless there's a consideration. Agree or disagree with it. There are other contracts where the court will say, I don't care that you want this contract. There's a public policy against contracts to do something which are unlawful.
Yeah, we leave aside public policy.
But in a sense, there is a policy where the law intervenes and says, I do not regard what you have done, despite your intention, as being a contract.
Well, it's not a policy. I mean, it's just the law.
The law says, I'm so sorry, as articulated by the courts.
I think we'll
only make people
blind consideration was, but it's still the law.
It is the law. And if you're going to, with respect, I obviously accept that. If you're going to not give effect to the intention here, of the parties here, you have to identify a policy. Now, as I say, there may be a policy which arises from some statute, but we're not talking about that. We're just talking purely about the common law. And if you're going to say, let me start from a different place. Your Lordships and your Ladyship will be very familiar with what Lord Justice Bingham, as he was, said in a case called Pagnan, about the thing about contract law is that the parties are masters of their own contractual fate. Now, that applies as much to a variation where they are masters, or maybe master is no longer the right word, of their own contractual fate, as it does to any other agreement between the parties. If, therefore, the law is not going to have regard to their intention, one has to identify a policy as to why it should not do that, which is, at the moment, we're just talking about pure common law. We're not talking about penumbral tax statutes. In my respectful submission, you will not find a policy which justifies intervention, which justifies the disregard of the party's intention.
But I mean, if you're looking at the pure common law, it doesn't matter how you categorise it. No. The change is a contractual change. You use a contract to make the change. It doesn't matter.
Well, your lordship is right, and that's the point that was made by Lord Justice Toulson in the Wadlow case. Most times, contracting parties couldn't care less whether you say what they've done is a variation or a new contract, because why would they care? But there are situations, and this is one of them, where it does matter. Now, the two or the three that we identify...
If I may interpose, why does it matter? Because there's an overlay of a statutory provision that has to be made to fit.
With respect, no.
Or applied.
No, it may matter for different reasons. Your Lordship is right in one respect. It comes up in a variety of contexts. We've tried to identify a few in our written case. The first context in which it comes up is where you have formality cases, and there is a statute in the background. There it's a statute of fraud.
I think that rather makes the point I was putting to you. If you've got a statute that says, well, we'll enforce some contracts, not others, then you get drawn into having to draw a distinction between different...
But it doesn't tell you the answer. You get drawn into the debate because there is a statute which, in a sense, affects... It makes a difference whether there's a variation or a rescission or something else, because there's a statute which causes that to matter. The Limitation Act, in the context of employment law, is another one, where you have the cases where, because if you're going to take an equal opportunities point, you have to take it within 6 months of the contract terminating. Yeah. There is always a debate as to whether a variation terminated the original contract or not. As I say, the formalities cases, you have it because you have a statute, the statute of fraud, which prevents the variation from being effective, and you're then in a situation where the variation can't count, the parties are plainly intended to change their contracts, and the question is the variation which is ineffective such as to bring about a rescission of the original contract or not? And that's how it arises in the context against the background of the statute of frauds. So there's usually a
It's quite important. It wasn't the statute of frauds. It was the Sale of Goods Act.
Sale of Goods Act.
And the
It had to
importance
be in
is
writing.
that it was not invalid, it was unenforceable.
Unenforceable.
So there wasn't a sort of the same sort of public policy. I mean, that was quite important, I think, in those cases. It was a more neutral sort of provision.
I can see why. I can see why.
And the same may apply where regulatory control is extended.
Yeah.
The Act may say, well, this Act doesn't apply to services provided under a contract made before a certain date.
Yeah.
And then you've got to, I suppose, ask whether the services are being provided under the original contract if they're radically changed
Yeah.
by a variation, so as to apparently bring them within the mischief of the statute.
Indeed.
But the ambit of party autonomy, to call it a variation or not, may be greatly affected by the purpose behind the statute.
Well,
I mean, just take that as an example. Suppose that the pre-regulatory contract was to perform services X. They then decide to regulate from a certain date services of type Y, but not in relation to contracts made before a certain date, and they then change this contract so as it provides for services of Y rather than X. Well, you obviously got to look at the mischief of the statute to see how wide the margin of appreciation of the parties is to describe it as one thing or another.
but that's interpretation of the statute rather than of the contract. Yeah, but we're not.
It's
we're
difficult
not,
to think of any
issue 2 is
situation
not
other than a
Well,
statutory
I accept
one.
that. Issue 2 is not about that.
Take
though.
this situation, the holiday example. Suppose you went and booked your holiday and you booked it very early because they were saying if you book your holiday before the end of January, you get 30% off. So you book your holiday. In the middle of March, you decide actually you want to go to Paris, you want to go to Brussels, and you want to take the children with you, but you don't want to lose your 30% discount. So they may say, well, let's vary the contract then, so it's still within still made before the end of January. You have to pay more, but you still get your 30% discount. And you say, if that's what they want to do, let them do it.
Yeah.
Why does it matter?
Exactly.
But if some third party is providing the discount,
Well,
Then it's a matter. Then it's a matter for the third party.
Well-
The third party can say, "I don't care what you've done. For the purposes of my discussion with the travel agent, I don't regard this as coming in." But that's issue 3, not issue 2. So there are lots of examples.
Issue 3 might be so it's suppose then the travel insurance they had only covered contracts for journeys entered into before the end
exactly.
of January. Then the insurer might say, well, in our insurance contract, that's not a contract entered into.
I completely accept that, and that's the sort of point that arises at issue 3.
But as far as whether they get the 30% discount from the travel agent, that's between them and the travel agent.
Yeah, and if they agree it's a
There's
variation.
no policy reason
No.
to stop to say, no, you have to pay more.
Yeah. So
your submission is we've got to look at this issue 2 on the assumption at this stage that there is no policy that would actually override the parties' common intentions. And that the only, well, I keep on saying, putting words in your mouth, one restriction is going to be sham, but otherwise
there may be others.
there's nothing being articulated at this point, and we're not to take into account at this point of the argument whatever we may be thinking about the statutory interpretation.
Indeed. Well, I put it slightly differently because I do say that you shouldn't have regard to the policy of the statute when you decide this question. But I also identify the question of policy as part of the consideration of what the answer is to issue 2. Because as a matter of general contract law, Lord Justice Bingham, parties are masters of their contractual fate. If there is a reason why you're not going to give effect to the intention of the parties, there has to be, within the common law, a policy reason why you're not going to do it. And I accept when you have sham, when you have something else, there is a policy reason not to do it.
And that's why a lot of the categorisation cases presumably have the shape that they do have, because there is a policy. It may be to protect one of the contracting parties, or it may be to protect third parties who want to rely on these things. So that's why we have issues about whether it's a floating or a fixed charge and so on. There is some clear policy. That's your submission, is it?
That's my submission. Those policy considerations arise because of the context, the legal context in which the contractual question arises. The policy questions are brought into play once you've decided what the parties have intended. You can say this doesn't count as a fixed charge, it counts as a floating charge. But that's got to do with the categorization brought about by property law or land law. It's got nothing to do with the common law of contract, if I can put it that way. And what we're on issue 2 is the common law of contract issue. Let me, I don't know, I'm rather running out of time, I'm afraid, interesting though it is for me at least. Can I just say this about the authorities? And perhaps just identify what we say the authorities tell you, and then give you specific examples. If you, in our respectful submission, if you go through the authorities, and I have in mind the fact that when you look at the authorities, actually, let me say some points about, as a matter of principle first, and then I'll come on to the authorities. I've already identified the point that, as a matter of principle, the way in which English law applies is to give effect to the parties, and if you're going to impose some limitation on that, you need to identify a policy reason. My learned friends don't do that. The Court of Appeal haven't done that. With respect, there is no policy reason. The second point we make in relation to principle, if I can put it that way, before we get onto authorities, as a matter of principle, we say you wouldn't do that. The second point we make is this. There is an acceptance by my learned friends, and certainly by the Court of Appeal, that the parties could decide that something is a rescission even though they made the smallest possible change to the contract. In other words, you have a contract for the building of a big property, they decide to change 2 windows, but for whatever reason, they say, we don't want this to be a variation, we want it to be a rescission. Okay? So they're ignoring the route, going to the root of the contract, because this is a change which plainly doesn't go to the root of the contract. But in relation to a change which plainly doesn't go to the root of the contract, the parties can, the law will give effect to their intention. They want it to be a rescission, the law will treat it as a rescission.
Even if they just want to insert a semicolon in clause 275D,
they can say
they can do it by way of rescission.
You want to start again,
yeah.
This is going to be a new contract. The question that arises is, if that's the position and you give effect to intention, regardless of the root of the contract point, when the parties expressly choose to say it's a rescission, even though it plainly doesn't go to the root of the contract, why do you ignore contractual intention, parties' intention, as my learned friends would have it, and as possibly the Court of Appeal would have it, in circumstances where a change does go to the root of the contract, but the parties say, well, we know this is a big change, but we agree that this is a variation. What is the basis for ignoring that intention of the parties? There is an incoherence and an inconsistency in something which says we will only have regard to the intention of the parties if it's to say it isn't a variation, but we won't have regard to the intention of the parties if it's to say there is a variation.
Well, I think it's sort of, in a way, repackaging your first point of principle, actually. Because if there is a policy reason for saying that
That's fair.
you treat anyway, you've got the point.
I've got the point, but in a sense what it does is to drive you further in the fact that you have to find a policy reason, because there is otherwise an incoherence.
I mean, your whole theme on point 2 is freedom of contract. That is the policy of the law. If you can identify countervailing policies, fine and good, but you can't here.
That doesn't, and to be very clear, as they say in Liverpool, to be very, very clear about this, just saying freedom of contract doesn't get me home. I still have to establish that in circumstances where there wasn't an express, well, maybe said there wasn't an express agreement to vary, that there was here in all the circumstances an intention to vary. So,
yeah, I mean, that's the playing out of freedom of contract.
Indeed,
you say,
indeed.
in principle, freedom of contract. Now let's see what the parties intended
Indeed.
in exercising that freedom.
Indeed. So can I identify one? We've called it a point of principle, but you may say it's just a reflection of the need for policy as well. It seems to be accepted that the parties could agree a contract under which they say any variation, the parties agree that any variation within works or whatever it is will be treated as a variation, even if it changes very materially what we've previously agreed. And if they do that in advance, and they so define the power of variation, no one seems to say that you ignore that. In other words, even where you do have a change which goes to the root of the contract, if the parties have in advance expressly agreed that even changes that go to a root of contract will treat as variation for whatever reason, you give effect to that. And the question that arises is if you can do that at the outset, why can't you do that bilaterally? And in my respectful submission, again, absent some policy reason, no good reason.
Yes, yes, it's not so much why can't they do it bilaterally, it's really just a timing point.
It's a timing point.
People can express their bilateral intention at the outset and then everyone knows what's happening, or they can do it, if they haven't done that, ad hoc, but still make it clear.
Your Lordship's right, it's a timing point. And why should the timing make all the difference here? My respectful submission, again, that is incoherent and certainly...
And that goes to the point here, does it, that we had two express variation clauses, and there's no problem about those. And then is the argument that you're putting forward that what has happened, if it had been done by express variation clause, nobody would be arguing about it?
So the argument at this stage is at the point of principle. What should the attitude of the law be? But your Lordship knows it has a context, it has a knock-on effect in the actual argument we're making.
So the position, just going back to Paris and Brussels, you and your wife contract with the travel agent to have a holiday in Paris. You have the holiday, very good holiday. Mm. You come back, you go back to the travel agent and say, well, we've been to Paris now, we'd like also to go to Brussels. So you could then agree with the travel agent to vary your Paris contract to provide also for a trip to Brussels.
So the answer is, if you're expressly agreeing that, you can actually agree with them to vary it, say, well, can we just extend that contract? Can we just change that contract? So you include in that contract not only the trip to Paris, but also the trip to Brussels. With respect, no reason
that would be perfectly all right between the parties.
Yeah.
But if there was some travel insurance built on the Paris contract, yeah. If in truth it wasn't a variation,
of course, then
the insurer would be entitled to say, oh, I'm sorry, but you're not covered on the trip to Brussels.
Your Lordship is of course right, and that's issue 3.
Well, yes. I mean, I'm bound to say that the idea that issue 3 doesn't creep into this process somehow seems to me to be an extraordinarily artificial one. Because at the end of the day, none of this matters unless there are either third-party rights involved or statutory provisions which mean that the public is the third party and is affected.
In the end, it's going to matter. It's going to matter because we're going to have to look at it. I'm not saying Section 298 is ultimately not relevant. It is relevant, and it's going to matter. But as again, my submission is, you first have to decide whether you're dealing here with a variation, because if you're not, you don't even have to worry about Section 298. It's only if you are, it's only if you have got a variation that you've got any shot at all of saying that this is a contract, that this is expenditure that comes within Section 298.
And also, it's what the Court of Appeal decided, and we have to decide whether they were right or wrong.
Indeed, because it will be in textbooks. What you say about, I know it's the law, not the court, but what the court says about this will affect the way people regard whether there's a variation, whether you can expressly vary thing, notwithstanding it goes to the root of the contract, or whether there's some other different test that applies in the law. It's an issue which can make a difference. It certainly made a difference in the context of, for example, the employment cases. We've included 3 in our case. Not the Uber and the Deliveroo ones, but there's Dow, there's Cox, and there's Potter. All of those arise in a context of a statute, limitation statute, where it absolutely mattered to decide whether what had happened was a variation or a new contract or a rescission. It absolutely mattered. It matters. You have to decide the common law separately from the context. Then you apply it to the context. Then you get your decision. The common law and how it treats the difference between variations and new contracts cannot depend on context. You have to apply it to the context thereafter.
I think Lord Justice Newey, just coming back to this express variation clause, just left to one side what the position would be. had there been an express variation clause.
Yeah.
But you're saying, well, it's clearer than that. If there was an express variation clause, that would have been the end of the argument.
In this case?
In this case.
In my respectful submission, yes.
And then your submission becomes, does it, that what has happened is equivalent to
Precisely.
express variation.
Precisely. If intention matters, the easiest way of finding intention is if the parties have expressed it. And if there had been an express variation clause here, I suspect the parties wouldn't be here. But there isn't an express variation clause here, so that even if I'm right, the court is then going to have to say, in the absence, if the intention matters and there's not an express statement of that intention, can we find it by inference, implication, however you want to put it? And I do see that it is time for the short adjournment.
2 o'clock.
Thank you.